Good morning, Your Honor. Today we have a pre-trial review and an application hearing in the matter of CFI 002-2013 between SPX Middle East and Judi for Food Industries. Claimant is represented by Judi, leading counsel Hamish Lal, assisted by Naomi Miles. Defendant is represented by Karbal and co-legal consultants, leading counsel Dr. Muhammad Karbal.
Yes, thank you. Well, good morning, Mr. Lal, Mr. Karbal. Yes.
Your Honour, can I just check in terms of housekeeping that you received the application bundle, the application?
Yes, I have three bundles. One contains your skeleton with one or two appendices.
Yes.
And I have two hearing bundles. Although sometimes it's quite difficult to work out cross-references between the skeleton and hearing bundles. But I think I've done my homework. I have sought to read the material that you regarded as directed reading in paragraph 1.2, your skeleton. But I don't promise I've picked up all the nuances.
Yes,
but I have a feel for what is in issue here today. Now, what you want to start with? You've got a number of applications.
Yes, well, unless you wish otherwise, my thinking was that if we start with order number 1, which is the strikeout application in respect of the defendant's counterclaim, if I take you through the provenance of the claim, the importance of the application, and so on. Your Honour, I need to apologise straight away that I have been difficulty speaking. Yesterday I lost my voice completely.
Well, I'm getting deaf, so it may be very, very problematic.
I'm fortunate that we have speakers, but forgive me if I time to time have to just clear my...
Well, take your time, it's very helpful if you keep what voice you have up.
Yes, thank you, Your Honour. Your Honour, this is in essence a very simple substantive dispute. Claimant says we've done the work, we've finished the work, there are 2 payments outstanding to which we have a contractual right. As is common with most construction projects, there is some snagging items that need to be completed. And those items would have been completed had it not been for the situation in Libya which gave rise to contractual force majeure. The defendants...
I understand what you're saying, that there were items outstanding.
Yes.
Whether you call them snags or not. And that they would have been dealt with, but they couldn't be because of the situation in Libya.
Yes, that's absolutely right. The other fundamental point, of course, is that the facility that makes milk and fruit juices had entered commercial production way back in December 2010. Now, the parties tried for a couple of years to reach an amicable resolution. That failed, and ultimately we ended up having to issue proceedings. In those proceedings, the defendant raised, whether you call it a defence or a counterclaim, that there had been a loss of profit, the loss of production caused by, it is alleged, defects in the work carried out by the claimant. Now, we say straight away, and this was one of the issues, Your Honour, that was raised at the CMC as a potential and sensible preliminary issue.
You said that in your case memorandum sheet, you indicated that one potential preliminary issue was the question of whether the claim for loss of reduction or loss of profit, whatever it may be, was excluded by the terms of the contract.
Yes.
So that was raised at the CMC, was it?
Yes.
And what was said about that by the judge?
It was raised at the CMC. Your Honour, I wasn't at the CMC. The CMC order was issued on the 7th of October, and the immediate stages were disclosure. And it's fair to say that we didn't get beyond the disclosure hurdles to resolve the preliminary issues. When the registrar, Mr. Beer, issued his direction that there should be, on the claimant's proposal, an application notice, we thought it was the most sensible forum to discuss the preliminary issue together with all the various procedural failings or breaches.
So, may I understand that? When we say that the issue, or the question of the preliminary issue, is never actually reached at the CMC, as you understand it. The judge never made any ruling on that point.
Correct. Correct.
And he made no ruling because he wasn't asked to, or because people forgot about it, or what?
Your Honour, my learned friend may have more information on this particular point,
Okay,
because
well,
he acted.
Noble may be able to help me on
Yes.
that. But anyway, you don't know the answer to that question.
No. But we have raised it, and as a fundamental.
It's quite late to raise a preliminary issue, like 10 days before a trial.
Well, of course, Your Honour, the trial timeline itself has stumbled, or
Sorry, I didn't quite hear what you said there.
the trial timeline itself has struggled because of the lack of disclosure and the other procedural issues that we're grappling with.
But I mean, the preliminary issue isn't remotely dependent upon disclosure. It's a pure question of law, isn't it?
Yes, you're absolutely.
You don't have to wait for disclosure in order to argue that a loss of profit claim was not open to the counterclaimant.
You're
So
absolutely.
why wait?
Well, there were two. Without going into the client's instructions, we had the CMC. We had the CMC order. We then set about doing the disclosure exercise. That then led to a number of difficulties. And in between that period, a decision was taken that we apprehended there would be some sort of disclosure hearing, that we would then deal with both issues at the same time. Not just for expediency or costs, but we didn't want to raise too many procedural issues when we were actually arguing about disclosure. So that period in middle to late November, where things should have been happening, expert reports, disclosure, that was consumed with the procedural issues. We apprehended that there would be a hearing. We apprehended that the timeline would need to be extended, and that the preliminary issue could be dealt with earlier than the trial. That's the only explanation for not having it
But
way
the
back.
reality is that whether the topic is determined now or at the trial, it's a very short topic. It doesn't, is not remotely dependent upon any examination of any document other than
Correct.
the contract.
Yes.
And that you have.
Yes, and that's the main reason we raise it as order number one. It does have significant ramifications, because at the moment we're scheduled for a 5-day trial. If there is no loss of profit issue, there's no expert evidence, which saves time, which saves cost. It also means that the trial timeline can be compressed. And this is not with all respect, Your Honour, a massive claim, and where costs are likely to become very disproportionate. So, the fundamental question about loss of profit needs resolution, we say, so that it bites on the disclosure order, it bites on the expert evidence issue, the timeline, and fundamentally costs.
Well, we may have to go into this a little bit more detail, but assume for the purposes of argument that the counterclaim cannot succeed because of the terms of the contract. There is still a residual dispute, as I understand it, that as a set-off against the outstanding 2 tranches of payment, it is said, and I'm not sure you dispute it, that the defendants would be entitled to set off the costs of putting right the snags, etc., that you were unable to do. That's common ground.
What, Your Honour, another clarification, what we say is that the 2 final payments, milestone 5 and 6,
Right.
need to be paid,
Yeah.
and the defendant would be entitled to the costs of any remedial works that
Right.
have been properly carried out pursuant to the terms of the contract.
Right.
That issue bites purely in respect of order number 3, which is disclosure, because as things currently stand, there is no evidence that's been disclosed of any remedial works having been carried out, and those remedial works having been caused by SPX's breach or snagging items.
Well, yes. You're saying that although in principle they would be entitled to recover the costs of remedial work, they can't prove it because they haven't produced any evidence of it. I follow that.
And of course, that's why we need the disclosure order number 3, because it not only deals with teasing out evidence of remedial works, but also we hope it will provide documents and correspondence to deal with why they chose not to pay for over 2 years. You see, it's important to understand.
Well, why does that matter? Why they don't? I mean, they have just decided not to pay.
Well,
So what?
yes, but if at trial it transpires, if we have proper disclosure that the defendant accepted that 5 and 6 were payable,
Right.
elected not to pay,
Right.
then that's compelling evidence to show that they had no real issue with the works. They just elected not to pay because the facility, I'm surmising now.
It's the reverse side of the coin. If they can't prove they had to do remedial work, by definition they owe the money.
Yes.
I'm not sure it adds very much as to what motive they had for not paying. If there was no remedial work to do, they owed the money, and you would be entitled to the money plus interest from the date at which it should have been paid, on the face of it.
Yes.
Okay.
Yes.
So you say that leaving aside the counterclaim, the crucial determination today is to require, you say, the defendants to produce any documents they have relevant to what I might call the set-off claim.
Yes,
Yeah.
and in order to assist, Your Honour, we've got the claimant's request to produce, which I say we would need to look at. Certain items would no longer be needed if the counterclaim goes out,
Right.
but we would then be left with certain categories which we would then need production of.
Okay, thank you very much. So those are the 2 principal applications, disclosure and strikeout.
Well,
Is there anything else?
yeah, Your Honour,
Apart from costs, leave that.
yes.
Yeah.
Your Honour, the strikeout application is founded on 2 bases, just for completeness. We have the fundamental contractual legal issue that it's in the contract. The decennial liability questions are just completely with the matter. We're not concerned with decennial liability.
Right.
And of course the defendant has not pleaded decennial liability. This is just, they've not pleaded decennial liability. The decennial reliance on articles relating to decennial liability have emerged more recently in this application notice
Right.
as a vehicle to resist clause 21.
Right.
My point is simple, that decennial liability is not pleaded. This matter relates to de minimis or snagging items. There is no total collapse or partial collapse or any health and safety issue in respect
Yes,
to
I'm
these
not
snagging.
familiar with that part of UAE law. It's a UAE law
Yes.
case, or is it a GIFC law case?
A UAE law.
Yeah. As you say, the extent to which the defendants rely upon provisions of the UAE law to overcome or set aside the exclusion clause, that's not pleaded.
Not pleaded and not relevant on the facts.
Right, not
Yes.
pleaded.
Yes.
Yes.
And second, there is no expert evidence, and that, although it forms the fundamental focus of order number 2, Your Honour, the claimant's position is there is no loss of profit entitlement, but even if they were, there is no expert evidence to support this. The expert evidence issue is, it's very clear. It started off at the CMC, and the defendant sought leave for an expert report. They referred all the way beyond the CMC order to an expert report, expert evidence, submitted something. We, the claimant, then raised serious objections that this didn't comply. And all that the defendant has done is to say, you're right, it's not an expert report. We accept it's not an expert report. This is, in fact, a report from a professional witness. And in respect of that, Your Honour, we say simply this. The person who was given the statement did not witness any contemporaneous evidence. What he has done is act as an external auditor and rubber stamp an internal document that the defendant had produced in May 2013. And I can take you to two more documents, should you wish, Your Honour. But it's beyond doubt. It's not an expert report. He's not a witness of fact. And we are completely lost as to see on what basis the defendant thinks that this document, let me call it a report or witness statement, is admissible. So, standing back, the counterclaim fails as a point of law, point of contract. There's no evidence to support it, expert or otherwise. And we've tried to tease out of the defendant documents, disclosure, to tell us what's wrong.
It's not necessary to have an expert witness to prove a loss of profit claim, is it?
No, I'm not suggesting, Your Honour, that it is. But having sought leave for an expert report to tell us that the expert will be actually carrying out disclosure, that the expert report will be coming on the 8th of December,
right.
Then to submit something, to give it some sort of legitimacy, but it's not an expert report, then to accept it's not an expert report, but to say it's now a witness of fact statement, this is just not, it's just not credible. And I don't want to labour the point because the claimant's very strong on the legal issue, the contractual issue. But it cannot be that this evidence, whatever it is, report or otherwise, should carry on. It has cost consequences because the claimant has got to deal with it. We've got to respond to it.
But I'm not entirely, I mean, you've had probably a shame of the document, but they've produced a statement from a person, correct?
Yes.
Yeah. They described it initially, at least, as an expert's report.
Yes.
Correct. They now say it isn't an expert's report, it's a factual witness statement.
Yes.
You say, on the face of it, it isn't a factual witness because he cannot speak from his own knowledge, and to the extent that it's hearsay, it's not probative of anything. And it's not a, I mean, it's not an expert's report simply because it isn't said to be an expert's report. In what other respects is it not an expert's report?
Well, there's three things there, Your Honour. Number one, the defendant accepts and states himself that it is not an expert report and they don't seek to rely on it as expert evidence. Second, it doesn't comply with the whole raft of issues within the RDC rules and so on.
Well, it doesn't, I'm sure, have all the appropriate pronouncements as how an expert should act. I understand that.
But it's also not reaching any expert conclusions. It's not making any expert conclusions.
No.
No.
To look at it.
Yes.
Say that it doesn't. Where is it?
But look, if I may, if I can take first of all to page. Oops. It is in your bundle, page 249, the application bundle.
No expense has been spared in this case. Right, and nearly there.
249.
249 or 349?
249,
Yeah, I've
Your
got
Honour.
that. It's in Arabic.
Yes, but there's two things to note here. First is it's dated the 4th of the 5th, 2013.
Yes.
And then over the page, at page 250 to 251, we have the English translation of it,
Thank you.
and provided by the defendant. Now, these documents came by way of secondary or the second tranche of disclosure by the defendant. Now, the document on page 250 is dated the 6th of May 2013.
Yeah.
And the fundamental difficulty straight away with this document is that it's not contemporaneous. It's May 2013.
Yeah.
It's not, in our view, disclosable. It was produced for the purposes of litigation. It's not a contemporaneous document. It's not a document that was disclosed as being something that went between the defendant and one of its team at the relevant time. It's been produced, we say, for the counterclaim. So it's not disclosable.
Well, it may not be disclosable, they've disclosed it.
Yes, it's not dismissible. Now, what this is an attempt by someone to come up with a big number. And that's what it does. It comes up with...
Well, it's a calculation, it appears to be a calculation of time loss, yeah.
But there's no
And
evidence.
loss of production.
And fundamentally, Your Honour, this document has no supporting evidence. There's no contemporaneous evidence, and there's no expert evidence to support any of these numbers.
Well, disclosure would be a separate matter
Yes.
from expert evidence. Right, you say
Now,
there is no underlying documentary material in relation to this apparent calculation.
no.
Right.
And, Your Honour, this document is the document that has been rubber stamped by the witness or
Right.
expert. And if we move to page 318 of the application bundle,
Sorry, nearly there. Yeah.
this is the document that was, this is the second witness statement submitted by the defendant. This is the document that is said not to be the expert report, but a witness statement. And what Mr. Ali, witness, has done is effectively take this document that we've just looked at, the May 2013 document, and rubber stamped it. He's an external auditor. He doesn't give us any contemporaneous evidence of the number of cleans or the actual kilograms of material used or costs. He's simply taken, word for word, this document in May 2013 and transposed it into this
I'm not sure
document.
it's right to say it's word for word the same. There are quite a lot of disparities between this document and the document we're looking at, page 250. It's much more extensive. But it doesn't grapple, you say, with the underlying problem, that there is no documentary support for the calculations that are set out here. It's not a rubber stamp of 250.
Well, what it is, Your Honour, is it's taking the accounting for losses document in May 2013 and effectively reinforcing those numbers.
Well, maybe the other way around. I don't know.
Well, this document is
Anyway,
dated...
there it is. I understand your
Yes.
point. You're saying, now this on the face of it, is it's not an employee of the defendant company. He works for as an accountant and auditor for a firm in Tripoli, and he's certifying or purporting to certify certain figures from the Judi production.
Yes.
So we're back to disclosure again, are we? Because so take, for example, where it says in paragraph 3, I refer to production reports marked Exhibit 1 and internal memos marked Exhibit 2.
Yes.
Where are they?
They are in here at the back on Exhibit 2 on page... Exhibit 2 is an Arabic document at 334.
334, yeah.
Now, the issue there, Your Honour, is even more basic. It's in Arabic, there's no translation,
Well, I follow that.
there's nothing to say it's contemporaneous, but fundamentally the objection the claimant has is that this whole loss of profit concept is likely to cause considerable cost. We say it doesn't work as a matter of contract, as a matter of law, but if it carries on, someone's got to get these documents translated. We've then got to get an expert to go back.
Well, then you're back on the point as to whether you should have a preliminary issue. I follow that.
Yes.
But if can we just stay on one topic at a time? Your point at the moment is that they haven't produced disclosure to support their counterclaim. And I was just asking what this document at 319 was and what the documents to which you referred was. And you say, well, it's on the face of it an expert's report. It's dealing with an assessment of loss as an accountant, and he's relying on certain documents, none of which have been translated into English. I mean, that's what you're saying.
Yes, with one clause, Your Honour, which is that it's derivative to an internal document produced in May 2013, which of itself we say is not.
Well, I'm not sure which is the chicken and which is the egg, to be honest.
Yes. But there we are. That's the issue with the expert.
Right.
We don't... If Order 1 is, as we say it ought to be, then Order 2 resolves itself, and then we are really left with going through the request to produce, to come up with an order for disclosure.
Right. So when you say Order 1, you mean strikeout?
Yes.
Right. And Order 2 is the disclosure?
No, Order 2, Your Honour, is
the expert?
Yes.
Yeah, okay. So, right, I've got the drift of the point. We're leaving this awfully close to a trial. How is it coming? I mean, here we are. I'm actually returning to England a few days and coming back and doing this trial. We're on the eve of the trial.
Well,
It's very unsatisfactory.
Your Honour, it's a very tight timeline. I mean, the CMC order was October. We the claimant...
Well, you were pressing for urgent action, but
yes.
If you press for urgent action, you've got to get your tackle in order.
Yeah, and we have. The claimant...
Well, you've left it awfully late. Okay, well anyway, that's very helpful, Mr. Lau. I understand, in a sense, the fundamental issues that arise on this hearing. No doubt I'll need more assistance from you shortly, but perhaps it would be helpful for Mr. Carwell to help me a little bit with where we are.
Sure.
Thank you, Mr. Carwell.
Thank you, Your Honour. just would like to give a background about this application, actually, and why we're here today.
Good.
The claimant has repeatedly sent various complaints to the court, developed to be aggressive emails and letters after the disclosure of documents November 1st. Got to the point that the claimant became a judge and that would want to strike everything, asking the court to strike out the counterclaim. Got to me personally, accused me of violating the code of conduct of the court. This led me to ask the court to intervene, to put the case on the right track and have a meeting to set the case forward. This is what Honorable Judge Beard, the registrar, came in with his email that led to the claimant to file this application. In his email, the Honorable Judge said that they have 7 days. He thought the correspondence was containing so many issues, such as disclosure, counterclaim, evidence, violation of the code of conduct. The Honorable Judge thought that was too much to handle through correspondence and asked them if they choose, as it chooses to file an application for whatever they think. Second point of the email was to stop correspondence and stop accusing the claimant or Mr. Lyle himself. Stop accusing me of violating unless they have approval.
Leaving aside, since the case management conference, which I think was in October,
2nd, yes.
Has any application notice been issued by the claimants in this case at all?
No, not at all.
No.
The complaint and
there are certain rules about making an application for disclosure or an application for a strikeout. I had a quick look through the documents. I couldn't find an application notice.
No, there was nothing. This is the first time we have a hearing.
So how are we here today? On what basis?
On what basis they chose to litigate the counterclaim in early time, in my
but
opinion.
without an application notice as such.
No, this is the only
And
application.
no supporting statement or anything. It's rather odd. Okay, I'm sorry, I've interrupted. Anyway,
no problem. So
you say that they spent a lot of time writing to the court. Fortunately, I've been spared that correspondence.
just a chain of emails that were unnecessary, in my opinion. I asked the court to intervene personally. I wrote to the court an email, and I told them, let's have a meeting. The reply of Mr. Lal was that, taking into consideration my failed promises, which I didn't really promise anything or failed to fulfill a promise, it became very personal. But that's another issue, not for this case. Now, the direction of Honorable Judge Beard was not to have a hearing for the counterclaim, in my opinion. The court
where do I find his direction? Can you tell me?
That's an email.
I think I've seen it, but I wouldn't say I can put my finger on it. Mr. Larkin,
It's on page 79.
Page 79, thank you. Right. Now, the alleged application notice is the document at page 58, is it? 16th of December.
Yes.
No, sorry.
26th.
That's the date of the. So I don't know when did you receive this document?
I think we received it at the same day, the application notice, the end of December.
End of December, something.
Yes,
And then there was 14 days to
to
respond.
reply,
And then the hearing was listed.
after they filed the application notice. But my point, Your Honor, is that this is not a direction by the court to separate the hearing. The court did not exercise its power under Rules 4.2-5 to have a separate proceedings. So
Well, it
here,
appears to include a suggestion, put it no higher, that
but it didn't.
the application notice should cover the strikeout.
If they chose this, I don't think it's a direction by the court. It's an option for them to exercise. In other words, the court did not exercise its power and order the parties to have this hearing. So the claimant here is litigating the whole case today, which is prematurely, in my opinion, because we have submitted evidence that they didn't consider evidence. We have submitted documents that prove the loss. And the documents submitted by the claimant himself, there is proof that there was losses of production. But we didn't want to really discuss these issues in detail because it's not a separate hearing. It should be discussed with the claim itself. So the counterclaim, in my opinion, and the Order 1 and 2 regarding the counterclaim and evidence should not be considered by the court because we have submitted remedial work. We have given them the report by a third party that have done the work. They have admitted themselves before there was a snag list, but a snag list could be very important. You can have a Rolls Royce for £3 million and a snag list of one bolt of 10 pounds. This is what happened in this case. They did not want to fix what they have admitted. They left in February 2011 when the revolution happened.
Well, as I understand, Scotland Ground, they left, and to the extent any remedial work was needed, they couldn't do it and didn't do it.
But the remedial...
is there a snag list produced by you?
Signed by them, and it's a part of
produced by them?
Yes, it was signed by both parties, and this was a year after they left snag list. And that snag list, they have admitted there was major problems with commissioning, problems with the software, problems with production.
Assume, therefore, as a result of, well, there were 2 points really. One, you say because they didn't complete the work, the production was interrupted or interfered with, and that led to loss of production and loss of profit. I also assume it's part of your case that because they didn't do the work, someone else had to do the work.
They didn't want to finish the work.
No, I follow that. But did you get anybody else to do the work?
Yes, from February 2012, a year after they left, until almost December of 2012, defendant has been calling them to come, finish the problems, finish the deal. They refused. They wanted to get paid first. But if you look at the contract, payment is conditioned on the TOC, the takeover certificate. Payment is not just to be given, you have to finish the work. Basically, the contract is very clear on this point. So the defendant said, we're not paying you because the work is not finished. But they wanted to be finished to finish the work. To be paid, I'm sorry, to finish the work. And that could not take place, Your Honor. So they had to seek a third party to finish the work. We submitted a document from a third party showing that a list of about 45 points were fixed. We are planning to bring the third party as a witness, but unfortunately, prematurely, we're discussing the counterclaim, and there is an attempt to throw it out. when there is a door for us is open to bring witnesses. We have submitted documents, we have submitted snag
Well, it's
lists.
rather late to be contemplating introducing a witness to speak to work done on outstanding matters. I mean, that witness statement should have been produced a long time ago.
Your Honor, we tried to get
Yeah.
a lot of experts. Now they're talking about experts. The claimant is the biggest probably in the world in this
Yeah, but
industry.
your own people, your members of Judi for food
Yes.
must know what was needed and what
That was
done.
a witness statement submitted by the manager,
Oh, right, okay.
where it
I haven't read
details,
that.
and I really didn't think we will discuss this in detail, Your
No,
Honor,
I don't want to get into the details.
because this is not a time for
Well,
the
let me understand. You say first, the failure to complete work. First, you say, is your argument,
Yes,
that failure is a bar to them recovering their outstanding instalments because they didn't get a TOT.
yes,
One. Two, the failure to complete the work led to a loss of production.
definitely.
Three, failure to complete the work necessitated engaging a third party to do it for them.
Sure.
And you had to presumably pay for that work.
We submitted the invoices.
Now, I understand all those points, at least so far as you say. The next question is to try and identify whether the case is in a fit condition for trial.
It should be, Your Honor.
Well, it should be. I couldn't agree more, but I'm not sure about it. So, can we, for the moment, take stock? The parties have exchanged statements of witnesses of fact, have they?
Sure.
Right. And you are calling people from Judi for food to come and prove
We'll
some
try.
aspects of the case.
Yes, we'll try, but it's very difficult. You know, the visas and coming into this country sometimes it's
Well,
difficult.
that's
for
a
us.
separate point. But have you disclosed a statement? How many statements have you produced?
2 statements.
Two.
Thanks. Yes.
And whether or not the makers of those statements can come here,
Yes, we'll
they
try.
deal with, do they, with the question as to what work wasn't completed and what the effect of that was.
Sure. Or we, if you,
Okay,
if,
that's
you,
what you said. I understand.
if the court permits the.
And if they can't come to give evidence because they can't get a visa,
Sure.
are you contemplating that they should give evidence by video from Tripoli?
We can plan for that. or
Yeah,
think
well,
about it.
it's not something you can do at the last minute.
Sure.
Right, we'll come back to that. But prior to the exchange of witness statements, there should have been full disclosure.
Definitely.
As I understand it, I think I understand it, the parties at least purported to complete standard disclosure, i.e. there was an exchange of documents.
Sure.
Correct?
Sure. Definitely.
The claimants then produced what is called a red fern schedule.
Sure.
Yeah. And I, of course, looked at that. Now, you never made any comment in the column that was designed for you to make comments about as to whether you would produce the material or,
Sure.
or if you wouldn't, why you wouldn't. Now,
That-
why hasn't that column been completed?
This was to admit that was overlooked, to be honest.
Yeah.
At the same time, we received a complaint from the claimant, and we're a small law firm. I was busy to reply to their accusations. They have created a paper mill, actually, for us that caused us a headache. We didn't reply to that, but we submitted the documents we have after that. If you look at that sheet, Your Honor, they're asking for evidence that we don't have. They're
Well, that's
asking.
if you haven't got it, that's all you have to say.
Sure, definitely, I should have objected. It would be in a timely
No,
manner.
not a question of objection. As I understand it, you're not objecting to the
Sure.
relevance of the material they're asking for. You're
Sure.
simply saying that you don't have it.
Our answer came late, unfortunately. But the issue here is.
Well, we need to perhaps look through that list in a minute with
Sure.
Mr. Lal. I don't know as to whether you really have grappled with the requirement to produce documents, because I suspect your experience is much more with the civil courts, is it? Here in Dubai, or are you a regular here in the DIFC?
No, I'm not.
And of course, under the DIFC law, the requirement for disclosure is much, much more onerous than it
Sure.
is in the Dubai courts. You must produce your documents, whether they're helpful or not.
We definitely did, Your Honor, but if they ask about a feasibility study, we don't have a feasibility study.
I'm just feeling my way here.
No, that's fine.
Okay, now, the next point that I think Mr. Lal makes is that although perhaps the issue of being able to strike out the counterclaim by virtue of the provisions of the contract was something that should have been perhaps grappled with some time ago, he says there doesn't appear to be an answer to that, and it would save a considerable part of the trial if that point was removed. But he says that you have some points of law to make about it, which you haven't pleaded. I'm not sure you're required to plead points of law, but it's helpful to know what the issues are. You say, what, that the exclusion clause is not enforceable, or that the exclusion clause doesn't cover this particular claim, or what? Or is illegal? What are your points?
There's 2 points to that. One point is that they have the main agreement, which is about 3 pages, and they have standard documents that they submit with that or whatever. I was not there. But they agree, the standard documents, which is the exclusion clauses in, it's considered sales and sales terms of conditions. It's about sales, when you sell something. But the contract is not a contract of sales. The contract is contract of installation. It's construction.
So that's point one.
Yeah, construction of a plant.
Yeah.
That falls under a lot of people don't see it as the law of the UAE, especially Article 878, where you cannot really limit your liability under this type of contracts. It's contract of construction. It can be a building, it can be a factory, it can be anything. But the mentality is that it has to be a building like this. And then you have to limit, even if it's construction, you cannot limit your liability at all. You cannot totally eliminate. There is an elimination here, not limiting. Limiting liability is allowed by law. You can limit your liability to a certain amount of money that would be, paid as damages. But you cannot say, whatever losses you have, I'm not paying you. And this is what we face in here. That clause 12 of the sales, which could be...
I think I don't want to get into this, but I think all the clause seeks to exclude is consequential loss, not direct loss.
I think it's excluding
anyway,
all damages.
The point you want to make is, one, it doesn't apply to this kind of contract. Two, if it does apply to this kind of contract, it's unenforceable as a matter of UAE law.
Definitely.
Right. Now, and those points do not emerge from the pleadings at the moment, is that right? But do emerge from correspondence?
It's in our counterclaim. It is a reply to this application notice. And we have repeatedly stated these 2 points.
Now, strike me strange, I may say it's a very strange circumstances surrounding what was originally your expert witness. Now, as a matter of law in this court,
Yes.
if you have an expert, there are certain preconditions to the form of his report.
Sure.
But importantly, he must be recognized and categorized as an expert, and that imposes upon him certain specific obligations to the court and not just to the person who's employing him.
Sure.
Now, the person that has signed this statement, I've forgotten his name, I've forgotten his
Mr. Ali.
Mr.
Ali.
Yeah. Mr. Ali describes himself as an accountant.
Yes.
Now he has, as I understand it, no direct knowledge of what the impact was of what you allege was the failure in completing the work.
Sure.
He is simply identifying what he understands to be the impact based upon the documents he's seen and the witness statements he's read. So he is an expert, isn't he?
He is the same experts that the civil courts, like in the UAE, appoints to, for example,
To the court.
by the court to look at some kind
So
of
he
document.
is unquestionably an expert.
He is. He
Yeah.
could be appointed by the courts in Libya, and he was. He
So
was
you
under.
say he was appointed by the court in Libya?
No, he had done work.
Has done work.
He is under oath, and that's his part of his job.
Right. Okay.
And basically,
So why do you now say he's not an expert?
well, it's the format he did it. The format that will be accepted by the court
Right.
was not a format that would be accepted by the court, actually.
Okay.
But if you look at it, and I wrote this in my reply, if you different jurisdiction with different prescriptions and terms for each expert. He is considered an expert.
I mean, one of the most important things that an expert should do is identify what he's read and relying upon. And I don't quite know what he has read and relied upon.
He had read that one in Arabic. That
But I mean,
production.
why haven't we got that in English? Have you been asked to produce a translation?
No, I haven't, Your Honor, but I had a hard time communicating with these people, my client in Libya.
Well, I have to say, it's not being conducted in a manner which I would have thought is consistent with the obligations of cooperation between the parties. Oh well.
It was a late production, Your Honor. We thought he would give an expert opinion, but he didn't. We changed it last minute, I think.
Okay. Well, I'm beginning to get to a clearer understanding of what has happened and what might happen. Right, now, thank you very much. I'm going to ask Mr. Lau for some more help now and try and get into a bit of detail. Now, starting what I call at first base, Mr. Lau, Mr. Cabal has said, has identified the points that his clients wish to take with regard to the extent to which your clients can rely on the exclusion clause. He's saying, as I understand it, first, it's not applicable to this kind of contract, and even if it is, it's not enforceable as a matter of UAE law. One of your complaints is that that's not pleading, although it's now, I suppose, contained perfectly clearly in the response to the application notice. I'm very anxious to avoid incurring expense which is unnecessary. Now those points are made clear to you, is it really necessary to amend the pleadings, or shall we just proceed as if those were issues in the case?
Well, I think it's more fundamental than that. The issue with loss of profit, we've got the exclusion clause that deals with, as you say, exclusion of consequential loss of profit. What the defendant is now submitting is that there are clauses in the UAE Civil Code that deal with decennial liability issues. Our point is that we are not...
You have to actually explain what a decennial liability is. I'm not sure I know.
If we... I think perhaps the best thing to do, Your Honour, will be to go to the actual... if you go to page 387 of the application bundle...
387?
387.
Nearly there.
And if we...
Sorry, all these dividers make life rather tricky. I'm there now.
387, this is dealing with the contracts of work,
Yes.
which Dr. Carball says this is.
Right.
Over the page at 388, we have Article 880.
Yeah.
And this is worth reading. If the subject matter of the contract is the construction of buildings, which this is not,
Yeah.
or other fixed installations,
Yeah.
the plans for which are made by an architect to be carried out by the contractor under his supervision, they shall both be jointly liable for a period of 10 years to make compensation to the employer for any total or partial collapse of the building they have constructed or installation they have erected, and for any defect which threatens the stability or safety of the building.
Right, you're now arguing a point. I'm just trying to identify whether you need to know that this is the point, good or bad, that's being taken.
Well, I apologise, Your Honour, but I think what we are saying is that there is no allegation that engages Article 880.
I follow you say it's not a good point.
So it's irrelevant. It's not a good point, it's not relevant, and it does nothing.
Well, then you'll be able to knock it over without any difficulty.
But, Your Honour, the point is that it should be knocked out today, at this stage,
Well, it should have been. If there was a point to be taken on knocking these things out, it should have been done months ago.
Your Honour,
Anyway, yes. I understand you say that 880 is no assistance to the defendants at all. Right.
And it causes, to allow this to carry on, causes considerable knock-on costs and procedural issues and so on.
It takes 1 minute for you to say what your point is.
Your Honour, my point there is that it allows the so-called issue of expert evidence, the issue of disclosure of records, production losses, loss of profit and so on to carry on.
Well, it doesn't look as if that's producing very much material.
No, it's not.
So what expenses are you talking about?
But if it carries on and it's not struck out, then the requests in the claimant's request to produce will, subject to Your Honour's decision, will need to be requested.
Well, we'll see, and the costs of complying with that, because the costs of making it
Yes.
have already been incurred.
Yes.
The costs of complying with it are going to fall on Mr. Cabal's clients, and on your view of the case, they're going to have to pay for that come what may.
Yes.
So, I have to say, when I looked through these documents, it didn't strike me your clients were very concerned about legal costs. Fantastic amount of money has been spent on this application.
Your Honour, the claimant is doing all we can to assist the court, comply with the rules, and do everything as professionally and accurately as possible.
Can I ask what my first question was to Mr. Cabal? Has any application notice been issued in this case?
Yes.
Where?
Lord, it's the application notice is at page 58 of the application bundle.
Yeah, I thought you were going to say that. That isn't an application notice. An application notice is prescribed, the form of it is prescribed. What, give me the page again?
58. Your Honour, this is the application notice that was filed.
Yeah, I know.
served,
That
and
is not an application notice in accordance with the rules. The rules prescribe the form of an application notice. An application notice running to what? God knows how many pages this is. This is what might be called a skeleton argument or statement in support of an application notice.
Your Honour, I apologise if there's been any
Well,
error,
I mean,
but
it's pretty standard, isn't it? That the rules provide for the form of an application notice, which, well, I'm not going to look it up now, but I mean, it's quite a short document, which in a sense identifies very precisely the orders which are being sought,
yes.
and has attached to it any witness statement that the party wishes to adduce in support of it, and in due course there will be a skeleton argument in place of the application. But I'm sorry to say, when I saw this document, I couldn't think whether it was. But there it is. You say that is the application notice. What's its date?
The 22nd of September. Sorry, December.
Where
And
do I see that?
that's on the page number 74 in the application bundle.
Oh, yes. So 2 days before the Christmas holidays, yes.
Your Honour, if I can take you to page 79 of the application bundle.
Yeah.
This is the registrar's direction.
Within 7 days. When 7 days expired on the 23rd.
Yes,
Yeah.
he said within 7 days to file an application in respect of all or any or all, as it so chooses, of the matters it has set out in correspondence, including...
Yes, all right. But again, all the more reason to stick to a standard prescribed form of short application notices, rather than spend... I wonder how much money you've spent on producing this document. I don't think. What are your costs so far?
Your Honour, the orders that we are seeking, we say are significant. They're important to the procedure.
Oh, that's
and,
a good point.
and it's very difficult to do justice to each order in such brevity. We've tried to keep things as simple and as succinct as possible, but as helpful to the court and to the judge.
That all you had to say was, we apply A for strike out the category, B for a response to the Redfern schedule, C to have an order that the alleged witness statement was inadmissible, and D, I can't remember what the other one is, but it would take 5 minutes to draft it. Anyway, there we are.
So,
let me just pursue the point I just raised. How much have you spent on this case so far?
for the cost schedule for the application,
No, on the whole case.
on the cost so far, I don't know the exact number,
Roughly.
but I would estimate circa $200,000. $200,000.
Right.
And it's not...
It's probably something like, what, 50% of the claim? I can't remember what
The claim is for
500,000.
€540,000 plus interest.
Yeah, so, okay, right. So not insignificant. Right, and then we were grappling with the pleadings at that stage. And I understand your point about Article 880. Can we now turn to the Redfern schedule?
Yes.
Now that I've seen a momentary loss.
It's in the application notice
Yes.
at tab 4, tab 13.
Nearly there.
No, it's in the tab, in the application.
Well, the application notice runs, does it, from page 58 to 100 and...
Your Honour, it's really in the actual tab 13 of the actual application notice.
No, I see, sorry. I don't have a tab 13, so you give me a page number.
It's not in the application bundle. It's in the actual application notice.
Well, I don't understand what you're saying.
Well, we have the application bundle, and we have the
I've got two application bundles.
Yes, we've got file 1 and file 2.
Right.
But what we have also is the actual application that was served on the 22nd of December.
Well, I assume that was page 58 and following.
Yes, but we didn't include all the tabs of the application notice in the application bundle.
I've never seen. Okay. Right. Well, so
I have a,
I think I've seen it because I actually marked my copy out, so it must be in here somewhere. What's it doing next to your skeleton? No. Okay, odd. Because I've definitely seen it, so it must be in the file here somewhere.
would it assist you on if we got a copy
Yeah,
of
well,
it?
give me a copy now to work with, yeah.
Yes.
See to answer. No, here we are, yes, I've got it. Page 138.
Yes, you're right, Your Honour.
So
I do apologise.
Notice runs, amazing. From page 59 to page 145. Startling. Alright, and I've got it. Now let's just see what this is asking for. You say your major complaint is that one of your complaints is that the defendants have not even bothered to answer or indicate their objection, if any. So you say, well, since they don't object, they must be admitting that they should look for these documents.
Two things, Your Honour. There has been no objection.
Right.
Second, there's been no explanation. Now, if there are no documents, but searches and so on have been made, then that's the defendant's position, and the court can take that into account
Right.
at the relevant period. But the suggestion that we, the claimant, should make effectively a summons for a third-party disclosure request of a contractor who's allegedly carried out remedial works is astounding.
No, I can't see any basis for you making a third-party application notice against somebody who's not even in the jurisdiction, as I understand it.
No.
So we can forget about that.
So the claimant's position is, if remedial works have been carried out, then let's have the evidence of it. Now, we are talking here of remedial works carried out some 2 years after commercial production
Right.
for a facility that is massive. You know, we did not build all of the facility. We built an installation which formed part of it. And all we were seeking were scope of work, correspondences, whatever, to help us, help the court to understand what was paid and what work was actually carried out.
Yeah. Well, speaking for myself, I'm not a great fan of red fern schedules, but those is just as if we have the habit of doing that. Now, let's quickly run through these. Request 1, the focus of this is documents relating to the remedial works, correct?
Yes.
And that is relevant because if they have some assertion that they're entitled to set off the cost of remedial work, then they disprove what that remedial work was. And if and to the extent they assert that they've looked for these documents and have been able to find any, which doesn't help them very much, they perhaps should produce a statement they've actually looked for and where they've looked and who's done the looking. Right, okay. So that's request 1. Request 2.
If I may,
I'm not
if
sure
I,
I know what documents being
Yes.
cross-referred to here.
well, Your Honour, if I can just explain, in one of the documents,
Yes.
there's allegations that the facility was unable to produce because the conditions had become unsterile. Now, without going into any technical issues, there can be multitude of reasons that cause lack of sterility. And one of the documents that they disclosed originally, and I'll take you to it because it's relevant in the current request,
Yeah.
is at application file 1.
Yeah.
Just bear with me, Your Honour. It's page 190.
Now this is the defendant's disclosure, is it?
Yes, this is the 10 or so documents that originally came on the 7th of November. Sorry, the 1st of November.
This is their standard disclosure.
Yes.
Yeah.
And the document on page 190,
Yeah.
putting aside whether it's contemporaneous or not,
Yeah.
if we look at the date column
Yeah.
and we go down to the 21st of December,
Yeah.
go across to the remarks column,
Yeah.
there's a statement there that says stop due to US generator system alarm, all tracks.
Yeah.
And it carries on, stop due to tray packer chain, stop due to overload in feed pusher of tray packer. If we go to the 20th of December, which is further down,
Yeah.
go across to the column,
Yeah.
it talks about delay in sterilisation due to exhaust output too high, and there are other issues. Production is delayed to fault in buffer table.
Right.
Now, the claimant's position was, in respect to that document, you need to give us more contemporaneous documents that sit underneath this document or actually explain or evidence all sorts of problems that the facility actually encountered. Now, they are trying in this...
Well, the point being, you want to establish that these interruptions were actually happened, or you want to establish that their interruption is attributable to your part of the work?
Both, Your Honour. Both.
Well, they look unlikely to have been invented. A very clever person to invent all this. The idea that we're going to go into the underlying document
Yes.
as to whether unsterile packets are curdling and not blowing
Yes.
seems to me a
Yes.
ghastly proposition.
So then, Your Honour, we're left with the second of your propositions, which is, where's the evidence to say that these issues or problems are ours? Because certainly the ones I've just discussed are not. If I may carry on, Your Honour, the issue with sterility, or the lack of it, is that there must have been discussions, and there must have been discussions with other people, consultants, and fixes.
Yeah. When I understand production records that are not listed in the spreadsheet, quite sure why you need that.
Apologise, Your Honour. The reason we say that is because the data that's given here only relates to 2010, whereas the reports relied upon
Oh, I see.
are for other longer periods.
Right, okay. The detailed documentation of the generator system, the overlay referred to in the spreadsheet. All internal discussions. Doesn't look like a document.
Well, there may be emails, Your Honour, between the
Well,
project
it might
manager.
be, yeah.
Yes, but
Yeah. And this is a very, very, very wide request for description.
Your Honour,
Okay.
it's
I mean, you're expecting them to go into the electronic documentation?
Your Honour, it's not that we are expecting. The situation is the defendant is alleging that it suffered all this loss, but it may have done, but it may be nothing to do with SPX.
Right, okay, that's the principal point.
Yes,
A, was there a loss? Was there a loss of production? If so, why?
yes.
Right, okay. Anyway, perhaps we needn't spend too much time going through this. Since the defendant has not asserted that there is any objection to any of these classes of documents, it's difficult to see how they can object to making a claim, what efforts they've made to obtain them. And if further efforts are made, fine, and if further documents are reduced, fine, but they've got to do it pretty quickly.
Yes.
Yeah. Then, is there anything that we need to talk about in terms of the factual witnesses? Leave aside Mr. Ali, forget him.
Yes.
Mr. Kabar tells me that his two witnesses are potentially stuck in Libya. They might not be able to get visas to come here. What are we going to do about that?
Well, Your Honour, there's two things. First of all, my understanding is there only is one witness statement, and that's from Mr. Azam Malik,
So
the
there's only
project
one.
manager.
Okay.
There's only one. And this is the first that we've heard of this issue that he is stuck in Libya. Trial date has been fixed for a long
So
time.
you say, well, if they need to have a video connection, they must get on with it and,
Yes.
and organise it.
Yes.
Yes. Okay.
I mean, he is the only witness, and we need, ideally, a face-to-face hearing would be the most.
Well, I agree, but if he can't come, he can't come.
Yes, but I repeat again, Your Honour, this is the first we've heard of this, so,
Right, okay.
but we're in the court's
Well,
hands.
we'll see. Maybe
Yes.
he can, maybe he can't. So then, Mr. Ali, I detect a sort of must be a misunderstanding here. I mean, Mr. Ali is manifestly an expert witness. Mr. Kabar says he is. Indeed, he is the sort of person who is regularly appointed as a court expert in Libya. On the face of it, he's an expert witness and should be categorised as such. But your primary concern is not so much what I call the more technical points about the form of his report and so on. But what is important that he should identify what he's relying on in producing his schedule.
Yes, Your Honour, again, there's a little bit of overlap with the first order. If the loss of profit issue can be dealt with, then we don't need any expert evidence.
Yeah, I follow that.
That saves the whole plethora of costs and ongoing delay.
Right.
The fundamental issue with Mr. Ali is, yes, there's all sorts of breaches of the rules, and we're not for a second waiving or accepting that those rules can just be idly ignored. But we do need to understand what he was told to do, what he actually did, and what he now relies on.
Well, let me understand that. You say you need to know what his instructions
What his
were.
instructions were, what he actually did by way of look. It's very easy to say I looked at various records.
Right.
What records? Because the records we
No, I
Yeah.
take that point a minute. Yeah, I thought of that.
and then to explain
Well,
that
I assume that his instructions were, well, I don't know, you say you need to know, but
Yes.
his instructions were, would you please make a calculation of what our loss of profit was
but the
as a result of interruptions and you say, well, unless he tells you how he approached that, identify what breakdowns there had been and why there had been a breakdown and what the financial consequences of that particular
Yes.
breakdown were, he can't, his evidence is not really of much help. I follow that.
and Your Honour, it's important to realise, you touched on this point yourself, his primary obligation has got to be to the court. As currently articulated by the defendant, is a witness of fact. And the concern that the claimant has is very tangible and it's very simple. If Mr. Ali is to be an expert witness, then his duty is to the court and he has to explain exactly what his instructions were, what he's done, and which documents he relies upon.
Well, I think that is a circular point. I mean, we've covered that. I agree with you. He is an expert. There can't be any doubt about that.
Your Honour, I wonder whether it's more apt to say he's not a witness of fact. And he's been accepted by the defendant as not being an expert witness. His report doesn't comply. So, in our submission, he's not really an expert and he's not really a witness of fact. He may have a professional occupation which is more akin to an expert, but for these proceedings, he's not really.
Well, he looks a really target for being knocked about. I follow that.
Yes.
But I mean, he's either a witness of fact or he's an expert. You say there's some third category which makes him not admissible. I'm not quite sure I'm following that, but it may be said.
Well, all we wish to say there, Your Honour, is that if he's not an expert witness because he accepts
No,
he's
I
not,
understood that.
yes,
I was saying in terms he is.
he is now.
Yeah, he is. Maybe he's. I mean, I feel like one of the problems in this case has been parties, and I don't quite think this, has spent far too much time sort of sending letters to each other and to the court without getting on with the matter in hand. I have to say that the origins of this application are rather a good example. So it's not surprising that cases, if I may respectfully say so, have been the shambles of that. So it's just as well we met today, dependent upon the outcome of the various applications that are being made.
Your
Now,
Honour,
what does that leave? We've covered pleadings, we've covered witnesses, we've discovered disclosure, we've covered expert witnesses. Anything else? What are the other topics?
Your Honour, there was just one point that I wanted to just expand before we leave the expert issue.
Yes.
You touched upon it yourself, that the English is the language of this court. The experts Exhibit B needs translated. There
Well,
are
when did you ask for a translation?
well, our primary position is it's not admissible.
When
Okay.
did you ask for a translation?
We haven't in correspondence. We've raised it in correspondence that it doesn't comply and so on. We haven't actually said we'd like Exhibit B translated.
Well, I bet there's somebody in your office who can read Arabic.
I'm afraid.
I mean, I can't.
No, but I'm afraid. Your Honour, there isn't. And B, it wouldn't be appropriate for us to translate it and then seek the
No, I
defendant's
thought it was
approval.
not for you to produce a translation for the court, but for you to have an understanding of what it's all about and what kind of document it is. Are you really saying there's no one in your office who speaks and reads Arabic?
Yes, certainly that's.
I'm surprised, but there's
Yes.
right, that's what you said.
But Your Honour, my point is being lost. I fear that it's really this, that allowing this expert or witness to carry on has got ramifications, both in terms
Well,
of
I think one of the
costs.
reasons that we got ourselves at this stage, you seem to have spent a fantastic amount of time sending emails to the court. I actually seen them. Perhaps I would ask the registrar about it. Why are you sending emails to the court?
If I may, Your Honour, just explain the problems of a lot of issues. There have been difficulties between both parties in correspondence.
Well, that's all the more reason to take out an application notice.
And we took out an application notice at the first point beyond the CMC. The CMC order was very clear. In our view, it wasn't complied with. We sought to resolve the issue sensibly. That didn't work. We then sought the court's assistance.
Well,
Your Honour...
The CMC was in October.
Yes.
That's 5 months ago, 4 months ago.
The disclosure...
And the trial is 10 days away.
The disclosure... Your Honour, the disclosure issues were not resolved. There was a disclosure order on the 24th of November, which was not complied with by the 8th of December. And Mr. Beer's directions were on the 16th of December. So the claimant has done everything it can on time and in order to keep the process on track.
Well, there we are. Thank you very much. Now, let's come back to Mr. Fowler then.
Your Honour, may I comment on what has been said, please?
Sorry?
May I comment on what has been said?
Of course.
Okay, the court order was complied with, and we submitted more documents on the 28th of November. We submitted documents 2 times before December. One was November 1st, and then for some reason I blame myself, we overlooked the request to produce more documents. But then we produced the documents we have on November 28th for the claimant to see no documents were produced. That's wrong, because as
that's after the request. That's after the rate fair schedule.
Yes, the court ordered more production of what you have, and we did. We did produce more documents. Now I have to say, all this production of documents is based on the assumption in the case information sheet that we said we have 2,000 pages, and we only came up with probably, as of now, 150, then we must be hiding something. This question has been raised in every correspondence. And the claimant himself has said in the information sheet 3,000 pages. And they submitted 500. 2/3 of it are emails with confidentiality thing and with a disclaimer. Some of it has 1 line in 1 page. So we cannot be held responsible for something we estimated. I asked my assistant last week, how did you come up with 2,000? Well, she said, I looked at their information sheet, it said 3,000. We don't have good access with Libya, so we must have this.
Well, that leads me to ask you this question, and I think it's an important one. Who has actually done the search for the documents?
Most of it myself and my
Have you
assistant.
been to Tripoli?
Yes, I have been to Tripoli.
Right.
I'm a Libyan.
Right. So you have done the search?
I have visited the Judi factory and I have collected the documents they had. I have corresponded with them later on, sent more documents as requested. Now, the other issue is the article in law. I'm not referring to the same article. I'm referring to an article on page 388.
Yeah.
388 at the top, Article 878.
Yeah.
That's what I'm referring to, actually. Has nothing to do with 10 years or 5 years or whatever. In construction contracts, you cannot limit your liability.
Well, okay, thank you.
And if Your Honor, if you look at page 395, I'm sorry, 389, next to it,
Yeah.
it says right here, Invenius APV, this is the company, the claimant,
Yeah.
conditions of sale of projects.
That's what I've seen that. Yeah.
But the contract itself is an installation project.
Right.
It's construction.
Well, that raises an interesting construction
Regarding remedial work that we have submitted, Your Honor, we have submitted the work that has been done by a third party, a sheet of it, 3 sheets actually, as with the witness statement, Mr. Malik. We have submitted the invoices that were paid. The other thing about...
We will see in due course about that. Thank you.
Thanks.
So, now what are we doing about Mr. Ali? He's an expert witness. We agree about that, do we?
Your Honor, with all these emails I was receiving, had other work to do, I was really...
No, I understand.
I regret taking this case. I regret taking this case. I said, you don't want it that way, fine. But actually, he's an expert witness, considerably an expert.
Now, one of the problems with his statement is that it really doesn't explain what he's been doing and how he's done it. Doesn't identify what his instructions were, doesn't identify what documents he was furnished with,
Yes.
whether he was furnished with all the documents that you've now disclosed, whether he's seen the statements, etc., etc., etc.
Yes.
And it doesn't, of course, also contain the sort of pronouncements that all experts must make about their independence and, importantly, their obligations to the court.
Definitely.
Now, where is he?
He's
in Tripoli as well.
He is, yes.
Is he also exposed to the problem of potentially not being able to get a visa?
Well, I'll, as soon as I leave the court today, I'll contact him and we'll let the court know.
When are you going, if at all, back to Libya before the trial?
I don't know whether I go back before the trial.
Sorry, forgive me just one moment. Right. Sorry, any more that you'd like to help me with?
Yes, I would like to refer you to the snag list of 2012,
Yes,
February. In that list, the claimant have signed all the problems with the factory, and they refused to fix it until somebody came in December of 2012 and fixed it.
Okay.
Now, there is a loss of profit there. The factory did not work. They were waiting for somebody to fix it. And the claimant refused to come. If you look at the emails, all the emails they provided, the condition is that you pay us and then we come. All the correspondence, all the documents, but they failed to look at the contract itself. The condition for payment is to sign takeover certificate. They argued that their commercial production was no commercial production. Commercial production, if you want it in the sense that you produce in a large production, yeah, there was. But commercial production of that's, you can sell that product and you make money, that wasn't. Yeah, the factory can produce millions of liters of juice and milk, but was still, they couldn't really sell it at all. So they stopped, they tried again. As of today, now, I have to go back to the documents they asked, Your Honor, and allow me, please.
Sorry, now what topic are we on now?
No, the disclosure. I want to discuss the disclosure, please.
Right.
Now, the argument is that we said 2000, we submitted...
Oh, forget about that one.
Yeah, but this was not mentioned today, Your Honor. It was mentioned all along. Until they found out they wrote 3,000. Anyway, they are asking for financial business plan. And I talked to my client about a business plan. They told me, we don't have a business plan. Whatever you produce in that country is sold. We didn't plan anything. And I'm sure they would have had it if they had it, they would have gave it to the claimant when they bought it. They're asking internal management accounts. They don't have internal management. The place is owned by one individual, run by one guy who's part-time in Libya. He goes to the UK, and he's in Libya for 3 weeks and the UK for about four weeks. When he comes back, all his PC office is taken. They're talking about a multinational corporation with records are in place, feasibility study, and all that they're asking for. They're asking for an email between the owner and the manager, 3 months email. I asked them if they have 3 months. He said they never corresponded by email. And he said in his own word, I challenge the claimant if they have 1 email from the owner. The owner doesn't write emails, but they wanted 3 months email. But documents we couldn't really submit. But by the 28th of November, whatever we had, we submit. Some of it would serve our cause, actually, the spare parts. They didn't have a record of it. Now they do, but not when they fix the problem. Even though if the claimant is interested, the problem is still consistent, in other words. They still have a problem with the factory, and they have to change parts every week. So they're still changing parts. If he wants the parts that they're changing, they didn't have them at that period of time. But if they want it last maybe a month, maybe they have it. So actually, we complied with everything that they have requested. But they're requesting something that cannot happen, especially in that country. And especially it's a small, very small factory. It's not a company. So I think the invoices, to Your Honor, they have submitted the invoices. They're claiming a lost product. The claimant should have went there after the snag list and they're asking for force majeure. There was no force majeure. They were asking for payment. They didn't say force majeure. They could have went, finished. The defendant paid 85% of the contract value. That's a lot of money. And to wait 18 months to fix it from the date they left, that costs.
Okay, well, let's not go into the merits of the case.
Sure.
Right, well, any more?
Not really.
No.
Thank you very much.
Right.
Your Honour, just one clarification.
Yes, of course.
I understand from the client that Azam Malik, the only witness that the defendant has, actually lives in Britain. So he either has a British passport.
Right. I mean, his statement's in here somewhere, is it?
Yes.
Where
Yes.
is
It's not helpful in that regard because he gives his address as Libya.
May I say
Yeah,
something?
does he live in England?
Yeah, but he just got his residency. I don't think he has a passport. We will ask him.
Oh, I see. He'll have a Libyan passport.
No, he's a Pakistani, actually.
Oh, right.
He just got a residency in UK.
Yeah.
He just got it 2 months ago. I don't think you would know more than me whether they gave him a passport by that time or not.
Right.
And I will ask him if he has passport. Certainly
I'm
we
not
will.
getting broiled than that. I've absolutely no idea.
There we are, Your Honour. It's just a point of help. If I may, can I just take you to 2 documents?
Yeah, sure.
In the application bundle,
Yeah.
page 196.
Yeah.
This, on 196, 197,
Yeah.
198, is the full extent of the invoices relied upon by the defendant in respect of remedial works.
Right.
And if we go to page 198,
Yeah.
we see that in the description it talks about software
Yes.
for KP filler and automation snag carried out in December 2012. It talks about other software snags and
Right.
HMI control software. We come back to page 196,
Yeah.
and this is in the description. It talks about a job number
Yeah.
and the Judi Juice Project 2013. Now, we don't know what the Judi Juice Project 2013 was. We don't know whether this work relates to any of the snags that were left by SPX. But we
I
do...
can't decide that point now.
Your Honour, but my point is simple. When we
You
look...
may well be right, but it's got nothing to do with the case.
No, but my point, Your Honour, is that it talks here about reference mail from Azim Malik dated the 31st of December 2012. Now, all we have requested by way of disclosure is that email.
Right.
And this is the email that the defendant said, well, if you want it, why don't you get it from Automate? Now, yes, we can draw all sorts of inferences, but we
Well,
want...
you'll be able to cross-examine Mr. Malik. Then why on earth hasn't he produced his own email?
But
there's no obvious explanation. The fact that they suggest you go to someone else is obviously absurd, I agree.
And the final point, which merits just making, the sole reason why the contractor, SPX, could not complete the snagging was the force majeure.
Well,
Yes,
an argument.
yes.
I don't
But
know.
we,
You're right.
the claimant has no issue with setting off or paying for defects that were properly carried out, which were part of the snags.
Yeah, but there's an issue
Yes.
of force majeure. So
Yes.
again, I have no
Yes.
feel for what the force majeure was. I don't
Yes.
know whether it's relevant. Okay, thank you.
It's-
Right, well, let me try and deal with the various points that have arisen today. This is an application by the claimants prompted or provoked by an order of the registrar dated the 16th of December last year, which appears to have followed a significant degree of correspondence between the claimants, the legal advisors and the court, and the registrar invited the claimant, given the complaints that appeared to be made, to file an application dealing with such matters as strikeout of the counterclaim and various other topics. The time for filing the application was, I think, 7 days, and 7 days later, the claimants produced what they categorised as an application notice, albeit that it was not in any form recognised by this court, and rather astonishingly ran to more than 100 pages with the various exhibits to it. That application notice sought various orders. It sought an order striking out the counterclaim. It sought an order that a witness statement tendered by the defendant from Mr. Ardy should be ruled inadmissible. It sought an order that there be disclosure in response to a red phone schedule which had been served in early November, and it sought a cost order. Today is the 30th or 29th of January. The trial is fixed to start in just over a fortnight. It's unfortunate, to put it no higher, that these matters are being addressed at such a very late stage in the preparations for trial. The matter ought to have been brought before the court a very long time ago. I suppose the starting point is the application that is being made to strike out the counterclaim. The counterclaim being a claim primarily in relation to loss of profit allegedly sustained as a result of incomplete or inadequate work conducted by the claimant on the defendant's production line. The principal defence that is tendered in respect of that claim is that a term within the installation contract which in effect excludes any liability for consequential loss, including loss of profit. Now this issue has been at the forefront of the claimant's position for a very long time, and it has to be noticed that in their case memorandum sheet for the case management conference, which took place 4 months ago in early October, it was indicated that that was an issue which might be appropriately determined on a preliminary basis. However, it seems the claimant got distracted by the issues relating to disclosure and never raised with the court the possibility that it was suitable to deal with the counterclaim as a preliminary issue. Whether or not the court would have acceded to that application, I do not know. But to raise an application for a preliminary issue 2 weeks before a trial makes no commercial or legal sense at all. It's far too late maybe even far too late to determine the issue before the trial takes place, although it could have been done on no doubt on a summary basis, and certainly no time for an appeal. Preliminary issues need to be considered very carefully and brought to the forefront at an early stage. It is right that at first blush, the reliance that the claimants placed upon the terms of the contract looks potentially well-funded. But there are arguments that the defendant raises in regard to the applicability and enforceability of the exclusion clause. 2 points in particular are taken as understanded. Firstly, that the exclusion clause is within an annexure to the contract, and on the face of it appeared to be concerned more with sale of equipment rather than installation of equipment. Second point that appears to be raised relates to certain provisions within the UAE Civil Code and perhaps in particular Article 2. Article 878.
It's also 882. That is.
Okay. Now, I'm not minded to decide that issue today, partly because it's too late, and partly because it doesn't seem to me that the court is sufficiently instructed on the issues that arise in the case, for which there is no fully developed skeleton argument, and so that the application for a strike exchange of documentation in terms of standard disclosure shortly after the CMC. And in early November, as I've already indicated, the claimant issued quite a lengthy red fern schedule of various documents that were being sought. It's a matter of regret that, for reasons which really remain unexplained adequately, the defendant never even filled in the red fern schedule to identify what, if any, documents they were producing, and what, if any, documents they were objecting to produce, and what, if any, documents didn't exist. As I understand it from Mr. Cabal, who appears very helpfully on behalf of the defendants, further documentation was in fact produced in the wake of the red fern schedule in late November. But the claimants, for reasons which are understandable, still feel that it's unclear that there has been full disclosure along the lines, at least, of the red fern schedule, which remains unchallenged. Mr. Cabal tells me that he was himself responsible for embarking upon the disclosure process, and I assume, therefore, had an opportunity to study the defendant's files, and may also, although that perhaps is less clear, have had an opportunity of looking at the defendant's electronic files, because there are certainly some electronic documents which look as if they are relevant and should be produced. It seems to me that in this state of uncertainty, it's important that Mr. Cabal, on behalf of the defendant, sets out in terms what steps were taken to comply with the red fern schedule request for documentation, and to indicate, as I've already identified, what documents didn't exist despite the search, or didn't appear to exist despite that search. What, if any, documents are not being produced as a result of any claims of privilege, and whether the batch of documentation produced at the end of November constitutes compliance with the red fern schedule. It seems to me that that should be set out formally in a letter to the claimant within 7 days. Next question that potentially arises relates to the evidence of the defendant proposes to call. There are 2 potential witnesses. Firstly, the managing director of the defendant company, and secondly, Mr. Ali, who is an accountant. Some suggestion is made by Mr. Cabal that there might be difficulties in one or either or both of these men being able to come to the court here to give evidence in person. That would be unsatisfactory, but I understand that there could be difficulties with regard to obtaining a visa. That matter must be investigated with the utmost dispatch. If there is some difficulty in either or both of them attending, the defendants must notify the claimant and the court, and if it is contemplated that they would be giving their evidence by video link, must comply with the protocol which is set out in the court rules to identify how that is going to be arranged and what steps are being taken to provide them with the relevant documents and so on. The experts have blown rather hot and cold as to what kind of witness he is. I think we've now come full circle, and Mr. Covell recognizes that Mr. Hardy is unquestionably an expert witness. That's manifest. He cannot speak with any first-hand knowledge with regard to what losses were sustained by the defendants as a result, they say, of unfinished or inadequate work conducted by the place. But when one looks at his report, it's wholly unclear as to what task he was invited to embark upon and what documents he has seen and the process that he has adopted in reaching what appear to be figures for losses which have an uncomfortable likeness to an unsigned document, presumably produced by the defendants themselves, which is within the disclosure. Again, this is a matter which needs urgent attention. Mr. Arya must be asked to provide a supplementary report which spells out what he was invited to do, what documents he has seen, and identify how he has used that documentation and or witness statements or any other information with which he has been provided to reach the conclusions that are set out in his report. At the moment, the report is of no assistance to the court without having that supplementary material. At the same time, Mr. Ali must be impressed that he must indicate in his supplementary report that he's conscious of the duties which are imposed upon experts in this court as set out in the court rules, so that the court is satisfied that he is aware of his obligations to the court and his obligations to maintain his independence. That covers, I think, most of the ground. Forgive me just one moment. And I should have added to that that to the extent that the claimant, the defendant, or the defendant's expert is relying upon documents which are written in the Arabic language, translations must be furnished to the claimant so that the claimant and, in due course, the court can understand what is set out in those documents and what those documents are. So there is quite a lot to do before this trial starts on the 15th of February. I rather get the impression that I haven't actually asked counsel that the estimate of 5 days is probably excessive. And it may be that there is room to reduce the length of the trial, either by starting later or finishing earlier. I know not which is the more attractive to the parties, but the court would welcome an indication in that respect. But as I've already, I fear, said several times, there is
You're on for me, the key issue really is the timescale within which the defendant needs to comply with Mr. Ali's supplementary statement.
Right.
Because we are only...
Have I put a time on?
No.
No. Well, I should have done.
You said 7 days for the Redfern schedule.
Well, there's a difficulty in imposing the same time limit, because presumably he would want to see if any documents emerge. I will say 10 days. I agree that's running very close to the line, but I'm not sure I can impose a tighter schedule than that, given the fact that the defendants are in Libya, and obviously communications are not entirely straightforward. Right, well, thank you for that. Just remind me, my last observation, in the CMC order, is there some order in regard to bundles and
yes, agreed bundles.
Okay.
But the difficulty we've now got is that we've got disclosure and supplementary
Well,
witness
it may
statement.
be that bundles will have to be supplemented, I'm one of that. Maybe have to be a supplementary bundle. I don't want you waiting to do anything until the supplementary material, if any.
Yes.
And it may be nothing will come, I don't know. I think you should, in a sense, proceed on the basis that you have what the defendants are going to produce. And you may well need to cross-examine the chief executive officer as to why there isn't other material or what material is missing. But I don't think you want to assume that there is other documentation, let alone a wealth of other documentation that's going to emerge. So you must proceed towards preparing a trial bundles with what you have.
Yes. You're on this one important clarification. Yes. You refer there to the managing director.
I'm sorry,
He's the only witness they actually have is the project manager.
I'm sorry, well, I
yes.
meant to refer to the yes. I misunderstood the
yes.
status. Well, then what I said must be, in a sense, corrected.
Yes.
For that. Right. Now, is there anything else?
Well, my question is, Your Honour, that whether the 15th is realistic. I mean, I understand what you say, and about agreed bundles and skeletons and so on, but given that it could be the 13th, or certainly the 11th, before the supplementary witness statement arrives, it's getting very, very tight.
Supplementary witness statement?
I thought that's what you said from Mr. Ali to serve a supplementary witness statement.
Well, a supplementary report, yes.
Yes, yes.
But we're not contemplating either party producing supplementary witness statements, are we?
No.
No. Supplementary report, Mr. Ali, may not have see the light of day until, as you say, the 10th of February or so. Right.
And my question for you, Your Honour, is whether we ought to push back the 15th by several days. There is a 5-day window, so rather than starting on the Sunday, we start on the Tuesday.
Well, that was one of the points
yes.
I think I indicated was a possibility.
Yes.
You say it could be completed in 2 or 3 days.
Well, subject to the question mark about the video link, which may delay matters.
Well, of course, the time. I mean, if Mr. I keep forgetting his name, the project manager, Mr.
Malik.
If he's in London, the time difference is 4 hours,
yes.
isn't it? So he would have to give evidence in an afternoon time period. My own, if you wanted me to guess, I cannot conceive that his evidence is likely to last more than a couple of hours. But it might, I suppose. I have to say, video link evidence for more than 2 hours is quite testing. Well, the point you're making is that a bit of extra time would be helpful, yes. And that we have possibly some slack in the
yes.
timetable, and therefore perhaps we ought to start a bit later. Right. But let's see what Mr. Kaval says about that.
Your Honour, just one other small point, which I think you've addressed but not necessarily mentioned in the order. It would make sense, given what we've just discussed, for the defendant to set out the position as far as the witnesses, their availability and attendance, because that has a knock-on effect.
Well, in terms of
availability, video link, yes.
And how they will give their
yes.
Yeah, I certainly should have put a time limit on that.
Yes.
I think that you need to be, the court needs to be notified about A, their availability, and B, the manner in which they're going to give evidence very quickly indeed. And the protocol in regard to video evidence must be grappled with in the next few days. Where are we? This is Thursday, is it? No, Wednesday. So, well, no doubt the Libyan weekend is Friday and Saturday. Well, I'll talk to Mr. Kaval about it, but I think we ought to be
Yes.
aiming for the position to be clear by the close of business on Monday. Okay. Right, 2 points then, Mr. Kaval, if I may invite your assistance. You've heard what I've said. If there's some, in a sense, practical difficulty about it, you must say it now. Second point, what do you suggest? What do you say about the possibility of starting the trial a little later than we originally planned?
Few days would be no problem, actually. I mean, if it's...
I mean, that would give us 3 days.
That's fine. I have no objection to that.
Right. I think what I'll do is, on that topic, say we will start on the Tuesday, but I will review that topic. Sorry, the parties have a liberty to apply to the court if they want to start a bit earlier, because you're the best person, you're best placed to determine whether what has emerged in the meantime puts a slightly different complexion on the timetable. Do you follow what I mean?
Yes, well, can I suggest we start on Wednesday the 18th? So we've got 2 days, Wednesday and Thursday. And
that is quite tight for 1, 2, how many witnesses have you got?
1.
3 witnesses. I mean, as presently advised, I'm assuming he actually turned up here,
yes.
How long would you be with the project manager?
2 hours.
2 hours, right. So, and perhaps the same sort of time with Mr. Ali. Well, that's quite a large chunk of the day. Well, I confess I'm nervous about starting on the Wednesday. I think we're going to fix the Tuesday, okay? And, okay. Sorry, the next point, Mr. Kaval. I can't remember what it was. Oh yeah, well, I've indicated that we really must find out what the position is about the witnesses
Sure.
on Monday evening, okay?
Sure, I'll let you know by Sunday.
Right, okay, well, we really must know.
Sure.
And as I said, if you're contemplating video connection, you must get your tackle in order.
Sure.
And speak to the court, you must fill in the appropriate protocol and so on.
We'd like to invite other witnesses by video conference, please, if you don't mind. We'd like to invite other witnesses to be questioned through a video conference, because one of them is in Egypt, I believe.
Now that catches me by surprise. You say you've got some other witnesses?
Yeah, we thought we have time for that. I'm sorry.
No, I think you really must be a bit more forthcoming.
I thought
Up to now, I have proceeded on the basis, and I don't think anybody suggested I was wrong about this, that you had one witness of fact. Now, are you now saying you have more than one witness of fact?
I am under the impression is that you can summon some witnesses a few days before the trial, or
you can, of course, subpoena a witness if he's within the jurisdiction, but I understand the person...
One of them is within the jurisdiction, yes.
Well, you could subpoena him.
Sure.
But I would have thought that was slightly dangerous venture, unless you know what he's going to say. Have you taken statements from anybody other than the project manager?
No, but the project manager tried to contact some people who worked in the project because they subcontract from the claimant.
Well, the whole point of the case management conference was to set out a timetable
Sure.
for the lead up to the trial, and one of the much earlier steps than the date of the pre-trial review is to produce witness statements in exchange for the claimant's witness statements. Now, if you're now going to try and introduce a new statement, you are going to have to make an application to the court.
Actually,
you'll be very unlikely to get
sure.
leave.
These people, they don't want to do it voluntarily, in other words.
Well, I understand that you may need to subpoena them, but
sure.
again, if you want to call another witness,
Sure.
you're going to have to get the permission of the court because
Sure.
you're miles out of time.
All right.
Okay?
I just have one more point regarding my answering to the Red Fern as a part of disclosure. As I said earlier, there was some kind of confusion in the dates. There was a court order and there was other dates, so I was kind of late in my reply.
Right.
But I have replied to it, and I will be more than happy to address it again. I have replied formally, but it was kind of late in my opinion, but I replied in a way each point they have, each document they have.
What I'm interested in, almost more than identifying what you couldn't find or the nature of what you did find,
Sure.
is to explain what you did. How you set about the task of identifying the relevant documents, where you looked, who helped you, and so on. Okay?
I can tell you now if
so,
you
just put that in letter form.
Sure.
Okay?
Sure.
Right. Now, have we covered the ground? I'm grateful to you for those. I shall see you on Tuesday fortnight.
There is a question of cost.
Yes.
You've seen the claimant's cost schedule. Defendant didn't serve one. It makes sense to do cost for the application, and fundamentally we'd like the court to consider ordering payment before the 15th.
Well, let's just get the appropriate order before the date
Yes.
of payment. Now, people were going to come here today anyway. It needed a pre-trial review, didn't it?
It needed a pre-trial review, Your Honour, but it certainly didn't need all the problems we've had with disclosure, the to and fro on witnesses and experts, and it certainly didn't need an application to deal with all those issues.
Do you have a schedule of costs?
Yes, it was submitted to the court on Monday.
Oh, right. It hasn't reached me for some reason.
I can give you a copy.
Thank you. Thank you very much. Thank you so much. Yeah. Mr. Gamal seen this, has he?
Yes, yes.
So how do you put it? After stating it's called it a judgment, but the order and reasons that I've just given reflect the need, particularly on the defendant's part, what you say about that, Mr. Carvalho. The reason we're here and we spent so much time...
Your Honor, I really didn't think it was necessary. We have replied to all their questions. We have answered all their questions. But it continued on the issue that we submitted 2,000, wrote 2,000 pages, we submitted less than that. And I don't believe that it's an order by the Honorable Judge Beer to file for this. It says here, as it so chooses. They could have chosen not to file this application notice. We have replied to everything they have requested in details, but apparently they didn't like the answers. So we put a lot of effort. We worked on this application notice more than the case itself, to reply to all these emails, 2 official complaints, and then we're surprised that it's an application notice. I think the Judge Beer was clear, wanted to end this correspondence, but he didn't ask them, it has to be, it's an order by the court to do it. It was a choice for them to do it. And the court did not order separate hearing for this counterclaim as they demonstrated today. Just they went in so many details that we were not ready for litigating the whole issue. We were not told this will be a litigation by the court.
Okay, thank you very much.
Thanks.
Yeah, Mr. Lover, any more?
Excuse me, Your Honour. Your Honour, look, it's patently obvious why we're here. It's patently obvious, reading the orders that you've directed, what now needs to be done and why those things need to be done. The claimant's position is we should get costs on an immediate basis, but very importantly, payable within, we suggest, 7 calendar days, payable to the client account of Jones Day from Carbon & Co. or directly from Judi, but certainly before the trial.
Thank you. Yeah, I think that this application was necessary from both the claimant's and the defendant's point of view in order to embark upon a pre-trial review and therefore a significant amount of the costs that would have been incurred in any event. But I've no doubt the costs have been substantially increased. On the one hand, by the defendant's failure to get their tackle in order, if I may call it that. I also think the claimant has opened his mouth rather too wide, in particular in relation to the application for a strikeout and the somewhat over-elaborate way that the matter has been brought before the court, have in mind in particular the extensive and somewhat remarkable application notice so called. I doubt that this will prejudice the claimant at all. I'm going to order that the costs be in the case. So that whoever wins the trial will get the costs of this application as well. I'm not going to make any order, by definition, for payment of costs within the next prior to the trial. Now, I should be assessing these costs, should I, or not? I think on the whole, well, I'm not being invited to assess them, so I won't assess them. Thank you very much, both of you, and very kind.